I have where my papers are.
Thank you for standing. Please be seated. Court is now convened in criminal number 12679, the State of Iowa versus Matthew Todd. Is it Kleve? Mr. Kleve is in the courtroom. His lawyer, Jim Shaw, is seated next to him. Ben Smith is here representing Sac County in the state of Iowa. It's my belief that the parties are here today to enter a guilty plea to one or more counts contained in the county attorney's trial information. Rather than wonder about that, I think I'll ask Mr. Smith, are you ready to go?
I am, Your Honor.
Mr. Shaw?
Yes, Your Honor.
Mr. Kleve, you had a chance to visit with your lawyer before you came in here today?
Yes, sir.
You know why you're here?
Yes, sir.
All right. Mr. Smith, why don't you address the court as to your expectations today and any plea agreements or offers that may have been made to the defendant?
Thank you, Your Honor. State's expectations are that defendant's plea will be taken, that defendant is going to plead guilty to count one of the trial information as filed in this matter on November 7th of last year. The trial information charged 2 counts, both involving a minor named or listed as John Doe. In the trial information, John Doe is specifically identified in the minutes of testimony, which are attached to the trial information and sealed for various reasons. In consideration, well, it's my understanding, Your Honor, that defendant is going to plead guilty to count 1 of the trial information. Count 1 is a Class B felony. The nature of the crime requires that defendant be sentenced to prison and that defendant serve 70% of that 25-year prison sentence, which comes to be about 17 years and change. In consideration for that guilty plea, the state has agreed to do a number of things. 1 is dismiss count 2. 2 is that the state will not, at least the state, both in Sac County and Cherokee County, will not file any additional charges based upon these same set of facts and circumstances or occurrences. There's been allegations that this has happened on multiple occasions, more so than is set forth in the trial information. And there's also been alleged that there are other, at least one other victim. So again, the state would be precluded from bringing any charges of that nature from here forward. That, I believe, and then as far as any financial penalty, the state would just ask that it be suspended, and that's a matter for sentencing. So I think that pretty much sums up the nature of the guard agreement. If defense attorney Jim Shaw finds that I missed anything, I'm sure he'll correct me. Thanks.
Shaw, you've heard the county attorney speak. Has that been passed on to you? Is that your understanding of the agreement and the position of the state? And have you in fact transmitted and communicated that to your client?
It is the correct statement of the county attorney, and I have communicated that with my client.
Mr. Kleve, you've heard the lawyers both speak. Did you understand what the state is expecting of you today?
Yes, sir, I
And
did.
you're willing to proceed on that basis?
Yes, sir.
I'm going to have to ask you some questions. During the course of this questioning, if you desire to speak with your lawyer, ask to do so, and I will allow you. Are you thinking clearly today?
Yes, sir, I am.
You take any drugs or medicine that would affect your judgment? Have you had a meaningful conversation with your lawyer regarding these charges?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
Are you currently charged or on probation on any other charges that might be affected by this guilty plea?
No, sir.
Count 1 charges you with sexual abuse in the second degree. It's a Class B felony. It's in violation of Iowa Code Section 709.3, 709.1, and 702.7, and it's affected by Iowa Code Section 903B. They state that upon a guilty plea, you would be required to be sentenced to 25 years in prison. It's a mandatory sentence, requiring 70% of that to be served before you could be considered for parole. In addition to that, Section 903B states that any person convicted of a Class C felony or greater offense shall also be sentenced in addition to any other punishment to a special sentence committing the person into the custody of the Director of the Iowa Department of Corrections for the rest of the person's life, with eligibility for parole as provided in Chapter 906. The Board of Parole shall determine whether the person shall be released on parole or placed on work release. The special sentence imposed under this section shall commence upon the completion of the sentence imposed under any applicable criminal sentencing provisions, and the person shall begin the sentence under supervision as if on parole or work release. The person shall be placed on the corrections continuum, and the terms and conditions of the special sentence, including violations, shall be subject to the same set of procedures set out in Chapters 901B, 905, 906, and Chapter 908. The revocation of release shall not be for a period of greater than 2 years upon any first revocation, and 5 years upon any second or subsequent revocation. A special sentence shall be considered a Category A sentence for the purposes of calculating earned time. You could be required to pay your court costs, attorney fees, any restitution or pecuniary damages that might also be applicable in this case. Has all that been explained to you?
Can I have a moment, Your Honor?
Yes.
Your Honor, I just reviewed with my client the terms of that special sentence.
In addition to that, you would be required to register with the county sheriff of your residence or any place that you might move within 5 days of release from custody on the sexual registry for the term of your life. You understand this as well?
Yes, sir, I do.
Mr. Smith, you know anything I've left out of this, the parameters of sentencing?
No, Your Honor.
Mr. Shaw, do you?
No, Your Honor.
Very well. If you plead guilty, Mr. Kleve, you're going to give up certain constitutional rights that protect every person charged with a crime. They include your right to a public and speedy trial and your right to a lawyer, even if you can't afford one. If you plead guilty, you'll waive these rights. Do you understand this?
Yes.
You cannot be required to testify against yourself. The state must provide evidence to prove beyond a reasonable doubt that you are guilty. In fact, the court would inform a jury that your silence is no hint of guilt. But if you plead guilty, you're going to provide that evidence and you waive this right. Do you understand this?
Yes, sir, I do.
You can subpoena witnesses to support your case. The state has to tell you who their witnesses are in advance. If you plead guilty, you'll waive all or a portion of these 2 rights. Do you understand this?
Yes, sir, I do.
If this matter went to a trial, a jury would have to find you unanimously guilty of this or any other counts before the court can enter judgment accordingly. If you plead guilty, you'll waive this right. Do you understand this?
Yes, sir.
Count 1, sexual abuse in the second degree, as defined in the Iowa Code Section 709, 702, and affected by Iowa Code Section 903B. How do you plead? Guilty or not guilty?
Guilty.
Mr. Smith, are there any other plea agreements that you may have overlooked?
No, Your Honor.
Any threats or promises made to you, Mr. Kleve, to cause you to plead guilty today?
No, sir.
The sentencing judge is not bound by the agreement of the lawyers. Do you understand that?
Yes, sir.
I have to have you tell me in your own words. Your attorney may assist you, but you have to tell me what you did that violates this law in compliance with the Iowa statutes.
On October 4th, 2008, in Sac County, I performed oral sex on a minor referred to as John Doe. Information.
It occurred here in this county.
Yes, sir.
Once again, the child was under 12.
Yes, sir.
So a voluntary act on your part.
Yes, sir.
And Mr. Smith, are you satisfied?
Your Honor, I don't want to get graphic or explicit, but performing a sex act, is it, the state would be satisfied if the defendant were to admit to
I think you said oral sex.
oral sex as far as defined by the code?
Uh,
If the court believes it's sufficient, then I'm fine.
No, I'm not going to, Mr. Shaw, in a delicate manner, you may want to ask him some yes and no questions that would encompass the sexual organs and the act itself.
Mr. Kleve, by oral sex, do you mean that you had the victim's penis in your mouth?
Yes.
Mr. Smith is nodding yes.
Yes,
You're satisfied now?
I am, Your Honor.
Mr. Kleve, we've encompassed a number of issues far-reaching. I want you to review in your mind the possible penalties, the significance of the penalty, the rights that you've given up, and I'd ask you once again, how do you plead to count 1, sexual abuse in the 2nd degree? Guilty or not guilty?
Guilty.
Should I accept your client's plea, Mr. Shaw?
Yes, sir.
Does the state agree?
Yes, Your Honor.
Was there any exculpatory evidence you did not share with Mr. Shaw?
No, Your Honor.
Court finds that the defendant is acting voluntarily, understands the nature of the charges, the possible consequences, has recited an adequate factual basis, and I accept your guilty plea to count 1. I'm going to order that a pre-sentence investigation be prepared as required by the 2nd Judicial District Department of Correctional Services to assist court and counsel on the date of sentencing, which shall be February 23rd, 2015 at 10:00 a.m. Your incarceration shall continue until such time. You have a right to challenge the plea that you just entered because of errors, omissions, and mistakes I may have made in what's known as a motion in arrest of judgment. Motion must be filed in a timely manner, no later than 45 days from the day, but at least 5 days prior to the date of sentencing. Your failure to file that motion would preclude you from ever pursuing it on appeal later. Anything else, Mr. Shaw?
No, Your Honor.
Mr. Smith?
No, Your Honor.
Court's in recess.